stories unfold, and the chat's got soul. From the gavel to the gas, we're watching it all. Covering the courtroom, big case or small. Laugh when we can, cry when we must, but it's all real talk, you can count on us. We're not the pros, just fans who care, with popcorn in hand and a comfy chair. And every twist, we're right there, together like we're all in the witness chair. This is the Broken Baker, where the trials come alive, where the chat is wild and the vibes survive. We're watching the worst of what people do, but we keep it light, yeah, that's our truth. It's the only place for crime, and it feels just right. We bring the justice talk into your night, so hit that stream, don't miss the call. At the Broken Baker, we cover it all. Oh yeah. We're just flaming with the view, but we ask the things the world wants to. Digging through the facts, side by side. Even when it's dark, we bring the light. No clickbait, no fake feels, just truth and the highs and the reels. With the chat that roasts and writes, we're just here for the case and the vibes. This is the Broken Baker, where the stories unfold, with a smile in the heart, even when it's cold. Yeah, we cover the bad with a wink and a grin, where the real talk starts, come on, jump in. It's the only place to be, can't you see? For trials and truth, it's BBTV. The Broken Baker, where the trials come alive. Yeah, we'll be here, trial after trial.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you might be. And welcome to the closing arguments in the Dustin Duren trial. 99% of you said he is guilty after we heard the defense side, which consisted of him probably talking himself into prison, in my opinion, showing no remorse really, even though he tried to seem like, oh, I shouldn't have done this. But at the same time, he had that argument that the Marines made him do it, and that was absolutely dumb. So yeah, that's going to be interesting to see how they're going to win it back on the defense. The defense team have done what they could, and that's about all you can say about that. You have a shitty case, you have a shitty client, you will not have a glorious case. Some defense attorneys can make chicken salad out of chicken shit, but most of them will just give you chicken shit again after. And sadly, these lawyers had nothing to work with. Some kind of scheme to abduct his kids, some kidnapping thing that doesn't really make sense. And yeah, as Sebastian said, he just kept digging and digging.
Good morning. Thank you. Please be seated.
And as soon as we're done
here outside the presence of the jury, 214-2024,
the closing will
CR028,
switch to the
Hampshire versus Dustin Duren. Good morning, counsel.
other
Morning,
case.
Mr. Duren. And I know that after the close of business, I did circulate the jury instructions consistent, well, what I believe with my orders yesterday. And Attorney Kettles, looks like you have questions on that or on something else?
Yes, Your Honor. And maintaining all of the previous arguments we made yesterday, I just wanted to point out one additional note based on the draft that was circulated last night. Starting at the bottom of page 12, continuing on about halfway through page 13, the discussion about the distinction between deadly and non-deadly force, we would ask that that be stricken. I don't think there's any dispute in this case that the force used was deadly, and so I think it is confusing to the jury to have them be doing this weighing of deadly versus non-deadly force, especially in this.
Good to hear you. You've been busy.
Knowing charge where deadly force is not one of the elements caused the death of another is one of the elements.
Okay, and I note that in the defendant's submission, which I denied yesterday and is again colloquially known in these parts as the NOMAR instruction, that in the defendant's requested instruction, there was a definition of deadly force that was in the defendant's overall requested instructions. I would note that for the record.
Yes, Judge, and reading the current version of the instructions, I think that this series of paragraphs with what the current instructions are a little bit confusing. And so just seeking to have the clearest and most simple language possible for the jury based on the court's ruling yesterday.
Okay, understood. Anything further, Attorney Garza?
No, Your Honor.
Okay.
We disagree, Your Honor. We think these instructions are appropriate. They were contained in previous drafts, as they are in this final draft. I don't think there's any reason to take them out. I don't believe it would be confusing for the jury to understand the difference between deadly force and non-deadly force in a situation where they're going to hear arguments after hearing testimony about someone who fired a gun at someone for allegedly hugging someone too tight. I think that's deadly force. That's not deadly force. It's important to know the difference.
Okay, all right.
And so, Judge, that sounds like the state wants this instruction not as it goes to Mr. Duren's use of force, which is the purpose, but to try to somehow bolster the actions of Ms. Naffziger, which is an improper purpose. If there's going to be an instruction on deadly force, it should be about the defendant's use of deadly versus non-deadly force. And the state just said that's not why they want it. They want it for a different and, I think, impermissible purpose.
I would
Death by
disagree
snoozing.
with counsel's characterization of the state's argument. I don't think there's anything else that the state needs to say.
It's just my Baker by
alright.
night streams.
Anything further, any party?
No, Your Honor.
Okay, all right. Defendant's request is noted. Defendant's request relative to that removal of that instruction is denied based upon the arguments contained by counsel, also based upon arguments as referenced yesterday during the charging conference, the lengthy charging conference, and also based upon the defendant's submission relative to jury instructions, which did include a requested definition relative to deadly force. I think that based upon the overall circumstances, the instructions adequately and reasonably set forth the issues for the jury to be decided with respect to this matter. So over the defendant's objection, that specific portion of the instructions will remain in as drafted, as prepared. Anything further, Attorney Kettles?
No, Your Honor.
Okay, Attorney Spicer, anything further?
No.
Okay. All right. Last bit of business, which I just want to make sure we
Hey, side-eye.
want to make sure that during
Boom.
just relates to logistics. I want to be able to make sure that I've established that I can I think under the circumstances, the best thing is to go back where it was yesterday, and I will simply move down to that portion.
That's gonna take us at least 20 minutes, Your Honor, of taping wires and moving the equipment and resetting up another monitor.
No, when I said yesterday, I meant at the end of the day yesterday. I just meant shifting that to the,
Back to where it was.
this morning.
This is over here, over this way. This morning.
This morning.
I'm not, no, I'm not talking about,
Thank you, I thought you meant moving it all the way this way, Your Honor,
Yeah.
I apologize.
yeah, I think,
And if the court, Your Honor, if the court needs or requires it, after we're done with closing and before, when the court is instructing, we can disconnect the cords and move the TV straight across the room.
yeah, no, I think under the circumstances, I think if I'm here,
Hey, Opal.
then I can maintain the most, it's a rather narrow angle. It's a narrow angle of being blocked, but I think I can see everything I need to be able to see for purposes of the record. If I position myself here, any objection from the state relative to anything?
No, Your Honor, we do appreciate it.
Okay, anything from defendant if I,
No, Your Honor, I just know that we now can't see that screen, so I'd just like to test, the state has said this
Yeah,
will still
the
work, but I'd
splitter is
like to
still
test
working.
it before the jury comes in, since we now can't see that.
please.
If you could just turn it on and make sure it's moving.
So I should ask Madam Clerk, do you object to vice?
No.
Okay.
Is your monitor power on?
Yes.
It's on this.
It's working on the judge's bench. We're not seeing anything on your judge. Wiggle wires.
Thank you, Delulu, for helping out getting the algorithm to suggest me to other people's. Hey, Miami.
HDMI no signal.
Oh. Hey, Danish lady. They shouldn't be allowed to touch anything in any courtroom, because every time they try, everything F's up. If we have any tech issues, we call
Now see this, yes.
the tech guys. No one touches anything, because the judges know they'll F everything up if they just try to turn on a microphone.
Reflect that, based upon the configuration of the courtroom, the court does find it to be
On Tuesdays, we do curls, because if you want to trade in Kevin and get the Jamaican bacon, your arms better be effing swole. Notrum bemerkum, you may want to do it now. Yes, I hope none of you are in Jamaica right now, because it looks like Jamaica is going to get hit by a very, very bad storm. But let's see if I can even mention what Canadian bacon is. It's a burger at Wendy's. Jamaican bacon is a beer can. That's what it says. That's nice. So Brandon says you can get a beer. Good. Yeah, I can. Oh, that's different. Yeah. Finally, Brandon didn't. I can finally share one of. Oh, I should just remove this one up there. See, a can of beer. The reason for this is that beer can said in English accent also sounds like bacon said in a Jamaican can, and vice versa. Brandon has risen and become different. Jamaican bacon. Just like Brandon said. Maybe Brandon, you all said he couldn't change. On the 28th of October, the year of our Lord 2025, Brandon made a good one.
Owens County Superior Court is now in session. The Honorable Donald F. Brazell presiding.
Franklin Bacon. Oh. Oh.
Okay, good morning, thank you. Please be seated. Okay, good morning, members.
I pulled it up, I showed it on screen.
Thank you for your service. As I told you yesterday, we're about to proceed with closing arguments from the defendant and from the state, and you'll also hear my instructions to you before you retire to the jury deliberation room to decide your verdict. The first matter, obviously, you can see in order to allow the presentation of certain items with respect on the screen, the screen has been moved over here. As a result of that, I'm stepping down here so that I can maintain visual contact with you folks as part of this proceeding. So I will do that during the closing arguments, and I've consulted with the lawyers, and they're in agreement with that. So I will be moving down here just so that I can continue to see what's happening. I can also see the screen from where I am here. So the first order of business, as I mention every morning, because there has been a media presence with respect to this trial, I again ask you if you have had any exposure to any of the media coverage, any information outside the confines of this courtroom, even if it was inadvertent. If you have received any such exposure, I would ask that you please raise your hand to indicate so, and we will address it at that time. Okay, please let the record reflect that none of the jurors raised their hands, so thank you again for following my instructions in that regard. And we are now at the point of closing arguments. And again, closing arguments, jury instructions, then at that point you will, once I give you the permission, you will be able to talk about the case and the evidence at that time. Okay, so anything further, either counsel before closings? Okay, I will, if you give me 1 second, Attorney Kettles, I'll move down here. I can offer the clerk's bench. I'll take the clerk's bench. That. Okay, thank you very much.
It is.
The law says that Dustin Duren is not guilty. The law says that Dustin was justified when he shot Caitlyn Naffziger. The law says a person has the right to use deadly force when they reasonably believe that someone is committing or about to commit a kidnapping. Caitlyn had kidnapped Dustin's child before. She had a plan to kidnap his children again. She told Dustin he would never see his children again, and she was holding Elowen hostage in front of him. Dustin reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin Duren is not guilty. This is a case of secret plans, broken promises, and a father's unyielding love. It is about a Marine reacting to a threat.
Is defense going first? Yeah, I would like, why the hell are they arguing for it? Okay, they're going to flip it around and say, no, this has nothing to do with it. But then I saw it was ponytails. Especially a ponytailed lawyer that looks kind of like it's a man's, I don't know what women has done to their hair, but it looks different than, this looks like a man's long hair. And men with long hair cannot be trusted. Just see Valhalla. Oh, that's right. I believe in New Hampshire, they only have one bite at the apple from the state. Isn't that how they use it? I believe that's no, the state didn't want to rebuttal nothing.
Toward his beloved daughter. A horrific tragedy,
Thank you, James.
but not a criminal offense. The law says that Dustin Duren was justified when he shot Caitlyn Naffziger. Dustin Duren is not guilty. Caitlyn Naffziger went to Dustin's apartment in Berlin in late February 2024 under false pretenses. She told him that she was there to drop off his daughter Valen, but she was actually there with a secret plan that she came up with together with her Aunt Brenda, a secret plan to take both kids to Minnesota without Dustin knowing, a secret plan to kidnap the children. And it wasn't the first time that Caitlyn Naffziger had kidnapped one of their children. When the family lived in Las Vegas, Caitlyn walked out of the house with baby Valen in a stroller. She pretended she was going to the park. Hours later, she hadn't returned. Dustin went to the park to look for them, and they weren't there. Caitlyn had taken the baby not to the park, but to the airport. She was flying to Minnesota with their baby, moving out of the state with Dustin's child, without telling him.
Well, I only know one Minnesotan, and I can understand why that is legal to pew someone in the face if they threaten to take your kid to Minnesota. Imagine them growing up to be lefty, enjoying the Packers and Bud Light.
Without getting his agreement, without
Didn't hear
even
any.
letting him say goodbye. Caitlyn had kidnapped Dustin's child before, and when she came to New Hampshire, she planned to do it again. Caitlyn and Brenda had a secret plan to kidnap the kids, to unlawfully interfere with Dustin's custodial rights, to take both Elwyn and Phelan to Minnesota without even telling Dustin. But that secret plan was interrupted. Caitlyn had to change her plan once Dustin began to figure out that something wasn't right. And here's what happened. First, Brenda drops Caitlyn off at the restaurant rather than sticking around to take Caitlyn back to her place in Hampton. Then, Caitlyn wants to go back to Dustin's apartment in Berlin, where she had told him before she didn't want to stay. The next day, Caitlyn won't tell him when she is planning to leave. Caitlyn is acting suspiciously. She's ignoring him, doing something on her phone, refusing to engage about what is happening with their children and what she is planning
If
to
they bring
do.
them back.
And this is the exact same thing that she did last time she kidnapped one of their children. And so Dustin is getting more and more suspicious. After Caitlyn ignores him all afternoon, Dustin decides that Caitlyn, who's refusing to communicate with him, is no longer welcome in his apartment. He tells her she needs to leave. She ignores him again. He tells Caitlyn it's time to leave and he will drive her back to Brenda's place. And to get ready to go, he puts Valen in the car seat near the kitchen. And when Dustin tells Caitlyn that she's no longer welcome at his place, Caitlyn's secret plan to kidnap the children is interrupted. Caitlyn realizes she is not going to be able to steal the kids away from Dustin without him knowing. And so Caitlyn changes her plan. She reacts. She grabs Elwyn to use her as leverage, to use her as a pawn to try to enact the plan. Dustin comes back into the living room and sees Caitlyn sitting on the couch, holding Elwyn from behind. Elwyn is straddled on Caitlyn's knee. Dustin tells Caitlyn, "Come on, we're leaving," and tries to grab Elwyn to get Elwyn ready to go. But Caitlyn
I normally
refuses
do
to
it
let Elwyn
after
go.
the closing statements.
She grabs Elwyn and she pulls her back. And Dustin lets
We can
go
do it now.
because he doesn't want to engage in a physical struggle with Caitlyn over their child. So he again asks. He starts to beg Caitlyn to let go of Elwyn. Caitlyn refuses. She says no. And at this point, Dustin's internal radar is going off. Caitlyn is refusing to release their child. She's physically restraining her. She's putting her at risk. And Caitlyn has been acting suspiciously. She's been acting the same way that she did the last time she kidnapped one of their children. Caitlyn is beginning to become a threat. Dustin is a Marine. He's trained to respond to threats. And he's responding at this point in the way he has been trained. He's at Condition Orange. He feels there is a danger to his child, and at Condition Orange, he's focused in solely on that threat and his need to protect his child. Dustin is begging and pleading with Caitlyn to just let Elwyn go. And Caitlyn again refuses. Caitlyn tells him that unless he pays her $2,000 a month, she is taking the children back to Minnesota and he will never see them again. Let's be clear, she is not asking for child support. She is not asking for money to help her take care of the children. She is asking for money so that he can have the children. She's asking him to pay her money so that he can keep the children. At this point, she's holding Dustin's child hostage, holding her for ransom, saying that she'll only release her if he gives her money.
Because she keeps using the Marines made me do it argument. The Marines didn't make him do it.
And she's also
Thank you. This is annoying. Your name is wrong because I know this is not your name, and now I can't remember your name. But you're from Western Australia, Perth, I think. I'm sure. I think. Thank you so much for the super sticker. I need you back on your real names because I get so easily confused. But thank you for the leveling up game control with big old arms. I hate that the names has changed. Thank you so much.
threatening to call the police and to lie to them, to tell them that Dustin took Elwyn to Berlin without permission, and that she's going to lie to the police unless he gives her money. And while she's threatening to take his children from him and make sure that he never sees them again, she's continuing to confine to restrain their child. Dustin feels like this is a hostage situation. Elwyn isn't safe. He's panicking. He keeps begging and pleading, begging Caitlyn to just let Elwyn go. She refuses. She continues her threats that Dustin will never see the children again, that she is taking them from him. And she continues to confine Elwyn in her arms. At this point, the tension is rising. Valen is crying from her car seat in the other room, and Elwyn is crying, both from the argument and from being physically restrained by Caitlyn. The situation is overwhelming. Dustin is scared for Elwyn. He needs to make sure that she's safe. His fatherly instincts, his protective instincts, are telling him that something is seriously wrong. The woman who kidnapped his child before is telling him
She didn't kidnap his child. They agreed that he would be driving home with one kid and she would be flying home with the other. There's no evidence of any kidnapping at any point. There's no police report. There's no family called, hey, I need my kid back. Just because you keep saying that he kidnapped her doesn't mean, because kidnapping is a legal term. This is like saying that Zach stole my heart. It doesn't mean I don't still have my heart. It just means that those pictures are very flattering when he's in the right light. Some of them you can almost see his face, but it doesn't mean he stole my heart literally. Her kidnapping her kid by taking probably a still breastfeeding kid with her to Minnesota with what seems his consent is not a kidnapping. Yes, give me your kids and your money. I'll let you have your kids if you give me money, but I'll take them away. No, the only proof that the state has, the defense put in was they put up that aunt who supposedly was supposed to help her steal the kids. And yes, they wanted to take the kids away from the home the next morning when he was sleeping so nothing would happen. But is it illegal? They had a shared custody. There was no rule saying, you're the mom, you can't see your kids. They were actually on a 50-50 plan, and he had the kids 2/3. So it's absolutely bullcrapio what this lady is saying. Can we cuss today? If it gets through, it gets through. And then you'll have to face Jamie after.
going to do it again, and this time he can see her physically holding their child hostage. Dustin, trying again to protect his daughter, tries to take Elwyn for the second time. And Caitlyn pulls her, yanks back again, and Dustin lets go. Caitlyn continues her threats to take the children and ensure that Dustin never sees them again. Caitlyn is escalating. She's getting more and more aggressive. She's kidnapped one of their children before, she's threatened to take them from him before, but this time is different. This time, she's holding his daughter hostage, holding her for ransom, right in front of him. This time, she's...
There wasn't any custody agreement, but he admitted that they had a 50-50 agreement, and he had the kids 97 days, and she had them 43. So, and again, this lady is just doing her job. This is what she does. Let's not yell at her for that, but it's just stupid. Of course it's working on you. You like a butch woman with a ponytail.
Confining his daughter, restraining his daughter, using physical force against his daughter. And Caitlyn had been on the phone.
Call the police.
Dustin's thinking, is there someone outside? Maybe Brenda, waiting? He's thinking, she's saying she's taking my kids from me. She must have a plan. And Dustin tries one more time to take Elwyn, to free her, to make sure she's safe. This time, he tries harder. He tries to grab one of Caitlyn's wrists with one hand and wrap his arm behind Elwyn with another so that he can free Elwyn from Caitlyn's restraint. But instead of letting go, Caitlyn gets more aggressive, more physical. Caitlyn braces her leg against the table. She yanks back even harder than she has before. She pulls, she twists, she bear hugs Elwyn. and Elwyn lets out a scream, a cry of pain from being yanked back by Caitlyn. Dustin and Elwyn lock eyes, and Dustin sees Elwyn's fear and her pain. And hearing Elwyn scream is horrific. It's a line that has been crossed. Elwyn is about to be kidnapped. Elwyn is in immediate danger. And so Dustin acts immediately. And he very, very quickly, with deliberate motion and without conscious thought, acts the way that he has been trained. The only thing in his mind is save Elwyn. His internal radar goes into condition red when a threat is so immediate, a danger so imminent that you need to take action. Like he had been trained, instinctually, automatically, he grabs his gun, chambers around, grabs the collar of Elwyn's shirt with one hand, and pulls her as far toward him as he can while Caitlyn is still restraining him. And while Elwyn is still in Caitlyn's arms, still being held hostage, he fires a single shot. And immediately after he shoots, Elwyn is released from Caitlyn's arms and she is freed. Elwyn wraps her arms around Dustin and he runs out of the house and puts her in the car. He talks to Elwyn and makes sure that she is physically unharmed. But he's still in this heightened mode, this need to protect his kids. He grabs what he thinks they would need, he puts Valen in the car, and he drives. And once he's on his way, once he knows both kids are safe, once he's out of condition red, he feels horrible. What has happened is tragic. Caitlyn is someone he cares about and who is important to him and his children. He knew that he had been acting to save Elwyn, but that doesn't mean he isn't devastated by what just happened. And he knows he needs to turn himself in, but he wants to spend some time with the girls first to make sure that they are unharmed, to make sure that they are okay, not just physically, but mentally. He calls his mom. He tells her he shot Caitlyn. He tells her to call the police. And then he turns his phone off so he can have some time with the girls. And he drives, checking in on the girls along the way. The following morning, he turns around and heads back to New Hampshire to turn himself in. And he is hoping to have a meal with the girls before he does so. But the police locate him first. He cooperates, he complies with their commands, he makes sure they know that there are children in the car, and
Hellfish, you were Army, you weren't Marines. Remember, they are riflemen first. So rules are pretty different from the Marines.
exactly where his gun is located. And he does these things to make sure his children are safe. And then he speaks with the police, voluntarily, although he's under no obligation to do so. He's still in shock when he tells them what has happened. He feels horrible about what has happened, and he doesn't want to blame Caitlyn. He doesn't know New Hampshire's law on justification, and he doesn't know the law of defense of others. All he knows is that he was acting to protect Elwyn. When the state played the video of his interview, the last thing we heard Dustin say was about Elwyn. He says, not that it even justifies anything, but it's like, she's just my everything. And Dustin's right that Elwyn is his everything, but he doesn't know the law.
Yes. Your understanding is wrong because only the Marines are riflemen first. Have you learned nothing? This guy is the guy. You couldn't be in a room with him 2 minutes without him telling you how he was a Marines.
The law?
They're not lying. They are trying to fit the story into the acceptable terms. Everyone has a 5th, 6th, and 8th Amendment right. I believe that's the rights that covers law. And remember, what we believe was a great defense in the Karen Reed case for some other people was just a bunch of lying liars who lied. So who gets to determine when a lawyer lies? Is it us or is it them, or should we let the jury do it? So that's why we have juries, to sit there and evaluate who is telling the best story. We can have all the opinions and say this is just bull hockey, but she's doing her job. It's also to protect the state from having to do it over and over and over again. If she just stood up there and said, yeah, find him guilty, he's a fuckface, because that wouldn't have been a proper defense.
Says that Dustin is justified. The law says that Dustin is not guilty. The judge will instruct you on the law. He will tell you, evidence has been presented that Dustin acted in defense of another with respect to each of the charges. He will tell you that you must find Dustin not guilty unless the state proves beyond a reasonable doubt that he did not act in defense of another. And the state cannot meet its burden. Dustin did act in defense of Elwyn. He is not guilty. The judge will tell you that when looking at the evidence that Dustin acted in defense of Elwyn, you should consider all the circumstances surrounding the incident. You should consider how he acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. The judge will tell you that Dustin had the right to use deadly force to defend Elwyn if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin's belief that Caitlyn was about to commit a kidnapping was reasonable. Dustin had the right to use deadly force. Dustin is not guilty. And consider all the evidence you've heard that Caitlyn was about to commit a kidnapping. And I'm going to highlight just 4 of the many things that you've heard. First, Caitlyn's own aunt told you that Caitlyn had a plan to take the children to another state without telling Dustin. Second, Caitlyn had kidnapped one of their children before. Caitlyn had taken one of their children, pretended she was going to the park, and actually gone to the airport to take Valen out of state, to move her to Minnesota without even letting Dustin know. Third, Caitlyn was holding Elwyn hostage, telling Dustin he was never going to see either of their children again. And fourth, Caitlyn was willing to harm Elwyn rather than let her go. Caitlyn was, in fact, attempting to commit a kidnapping. We heard it from her own family member. And therefore, Dustin's belief that she was about to commit a kidnapping is not only reasonable, it's correct. During jury selection, we talked about the fact that parents have a responsibility, a duty, to protect their children. And that's what Dustin was doing. He was protecting his child, ensuring she was not kidnapped. The facts are clear. Caitlyn was about to commit a kidnapping. You heard it from Brenda, and you heard it from Dustin. The law is clear. Because Dustin reasonably believed that Caitlyn was about to commit a kidnapping, Dustin had the right to use deadly force. Dustin is not guilty.
I've covered 2 cases, 1 case up
The
there
state
before.
gets to make its closing argument last.
Yeah.
And Dustin won't have the opportunity to respond. So let's talk a little bit about what the state is likely going to say and about the evidence the state presented or didn't present during the trial. First, you should not automatically believe that what the state is telling you is correct. The state showed you that in its opening statement. The state's claims about what the evidence would be in its opening statement were wrong, and they were misleading. Here's one example of when they were wrong about the evidence. The state told you, even put up on its big fancy screen, that Dustin was asked, "Fair to say you know you are endangering Elwyn," and that he said yes. But the sergeant, the police officer, the state's own witness, told you that what actually happened was the exact opposite. Dustin said, "Could it be that I'm endangering Elwyn by what I did?" And I would very much say no. Dustin was asked, "Fair to say you know you weren't endangering Elwyn," and that's what he said yes to. What the state told you about the evidence was wrong. What the state told you about the evidence was misleading. It told you that Dustin said the shooting was very deliberate, but it didn't tell you that that wasn't all he said. He said it was very, very fast, very deliberate. And that was misleading. That left out half the sentence to create a misimpression. The state also got it wrong when they said that Dustin grabbed Elwyn, she was in his arms, he stepped back, and then he shot. That's what the state said happened in its opening statement, and that's not what happened. And the state knows that's not what happened. The state had proof in their evidence that what they are saying happened is not true. Their claim that he had Elowen in his arms and stepped back is not true. How do we know that? We know that because the range of fire was close enough that Caitlyn's hair got caught in the slide of the gun.
Objection. May counsel approach?
It took longer than expected to get to obstruction. This lady lawyer isn't that well.
Objection.
How do we know that? That what they are saying happened is not true. Their claim that he had Elowen in his arms and stepped back is not true. How do we know that? We know that because the range of fire was close enough that Caitlyn's hair got caught in the slide of the gun.
Objection.
There has been no evidence of that. That's not what he testified. He testified, yeah, there was a hair on it. But that doesn't mean that because there was no stipling, there was nothing.
Striking the last sentence from the closing argument and instructing you to disregard it, and I will return to my seat now. Okay, thank you.
Yes, they shouldn't do the crap where they go for 2 hours.
This is State's
Has nothing to do with it.
24A. They didn't talk to you too much about State's Exhibit 24A. They talked to you about the gun, but not about the other half of the picture. The other half of the picture says hair removed from slide. So you will take it back with you, and you can see it right now. The police tampered with the evidence. They took the hair from the slide.
What? I am sorry. I'm going with John Gary now. This lady is horrible. She just lied. Catherine Williams, welcome. First time joining. This sounds like an awful case. I'll have to go back and watch, but does chat find him guilty or justified? 99% finds him guilty. And if you go back and rewatch it, just watch him on the stand being cross-examined. He is going to bury himself. His explanation is the Marines made me do it because they trained me to pew a 114-pound woman that I was also trained to unarmed combat. But listen to this lady.
Not about the other half of the picture. The other half of the picture says hair removed from slide. So you will take it back with you, and you can see it right now. The police tampered with the evidence. They took the hair from the slide.
May counsel approach?
Yes.
The police tampered with the evidence. Again, everyone has the right to have the best defense possible, and you should get the best defense possible, because if you have the best defense possible, there's also less likelihood that there will be any appeals that'll come through and get you out of prison. But this isn't the best defense. This is horrible. First, she lied about why there was a hair in the slide. Again, any of you who live with a person of the female whatever, of the female gender knows hair will be everywhere. I don't know how you can shed so much hair. I find my children's hair in my car still, and they haven't been in it for half a year. And yes, I do clean my car regularly. I don't know how women's hair can be everywhere. Get a nice high and tight like me. It'll keep it away. So you can't say that, well, it was when he pew-pewed her and the slide went back that her hair got caught, because then there would be stippling and burn marks, because it would be a close shot. And then she gets told, you can't talk about, you have no evidence of that. And then she just goes on and said, well, there's no evidence because the police lied about it. She's done this multiple times. You're not allowed to bring in hearsay. She goes right back, tries to put in more hearsay, gets admonished again, bring in more hearsay. It's been this constant breaking of the rules I don't like, because again, you deserve the best defense you can get. They're probably public defenders, but you still should have the absolute best defense that you can get to make sure that no rules are broken, because I don't trust the state. But your lawyer shouldn't be lying. The state shouldn't lie, neither should the defense. They can go the facts not in evidence way, right? This is gaslighting a toddler class. She shouldn't be allowed to say it, because when they get back there will be 2 jurors sitting there and say, well, you know, the state, they lied, because that hair, that was because he was really close to her, even though he said he was hip firing. So it wouldn't make sense. Remember yesterday he said, I pulled my kid back and then I hip fired, because when you shot 10,000 times, you can hip fire and hit someone directly in the dome. And their long hair will then flow out past your body and get caught in the slide. Her own statement makes no sense compared to his statements. Hey, Dawn Marie. No, it's a horrible closing. Yeah, this is bad. Isn't this dancing with a reason for a mistrial? No, I don't believe so. You would need more. You can still strike all of this and say, stop doing that, you absolute moron. And the state has a chance to correct it. So, no. Because he can't watch past the TV. That's why he's scooting over. If you look over here, they have a big monitor, because the state is probably going to use that to show a lot of video. And he can't see the jury that is placed down here. So that's why he's scooting.
Excuse me, members of the jury, I'm striking the last sentence of the defendant's closing argument based upon the totality of the evidence that has been submitted. Also, there was no evidence adduced during trial of any improper action in the collection of forensic data. Attorney Kettles, you may proceed.
Well, if you can get a drone, then maybe you can unalive someone from the Air Force.
24A shows that hair was removed from the slide. The state didn't present any evidence that it tested the hair. The state didn't present any evidence about whose hair it was.
So another one with long hair was in the room and did the shooting? Or was the gun so close to her head that her hair got stuck in the gun? You have to keep... What's this? Where's MG when we need a defense attorney who can tell us, what the hell is this lady? She's going for the jury nullification next. She's gonna Daryl Brooks the shit out of this case. First, it was her hair because it was a close contact hit. Now they didn't test the hair. Why should they test the hair? They don't have another suspect. Is she going to say it's someone else who did it? Oh my God.
The state didn't have its witnesses talk to you about the hair that was removed from the slide of the gun. And the state didn't talk about the fact that hair had been removed from the slide of the gun during its opening argument.
Objection, relevance.
And we can't know whose hair that was because the state didn't present any evidence, because the state didn't.
Your guy admitted he did it.
But we can think about whose hair it must have been. We can think about where Dustin said his arm was when he fired, and where Caitlyn was in relation to that gun and the slide of that gun. We can think about the fact that Caitlyn's hair wouldn't have gotten caught in the slide of the gun if he had grabbed Elwyn, taken a step back, and then shot.
But that's his testimony.
Caitlyn was still holding,
Thank you.
still restraining, still confining Elwyn when Dustin shot her. Dustin was justified. Dustin explained to you that Caitlyn was still bear hugging, still restraining Elwyn when he fired the gun. He explained to you that he pulled onto the collar of Elwyn's shirt with one hand to pull her forward to try to get her, but that she wasn't released from Caitlyn's arms. She wasn't safe until after he shot. The state may try to argue that that's not what he told the police, but you have the video. Watch it. They say that he stepped back. Nowhere in that interview does it say that he stepped back. Nowhere in that interview does he say that Caitlyn had let go before Elwyn was shot. I apologize, that Caitlyn had let go of Elwyn before he shot. I expect the state will make a big deal of the fact that the medical exam.
This is not a peen, even though it looks like it now. I look at it. He said, I was standing on the opposite side of the coffee table. She was sitting down with a leg up. I didn't draw that because I'm not good at drawing legs. Having the toddler in her lap. He then reached over with the pew-pew down at his hip level, grabbed the kid and fired and unalived her. And now this lady is trying to say, this isn't here, even though it's in his testimony. So he was right next to her. Or else you can't do that. You can't. His own statements was, there was a coffee table between us. I don't know how small coffee tables are in America. The ones I saw in the expert's house, yeah, I think I saw one, were big enough that you could at least sit 2 cups on it. So how could he have done what she claims? And he said he hip fired because he had trained 10,000 times to figure out how to do it. This makes no sense, lady. No sense. One story was he had the daughter, then pew-pewed. No, that's their story, the state's story. Also because that's what he said in his interview. But he claims now he was just holding her back and then shooting her in the head because she was out of danger because she's such a great marksman. Only her right foot. A peen gun would be great for concealed carry, but do they make them in micronator size? I could not hide even a 22.
Examiner told you that there was no evidence of close range firing. But that just means that some of the markers that the medical examiner would look for weren't there. The medical examiner told you that he couldn't say exactly where the shot was fired. He said that it's possible, he said on cross-examination, that it's possible to fire from close range without those markers being there, especially when there is hair overlying the entry wound, like there was in this case. There wouldn't be gunshot residue on the skin.
He did to the police.
If there was hair in the way. And there's been no evidence presented that the state tested Caitlyn's hair for gunshot residue. You have better evidence than the medical examiner, who can't say anything with 100% certainty, who wasn't there, who doesn't know whether or not this was justified. You have the photos from the apartment and from the autopsy. I'm not going to put them up again, but Caitlyn was sitting on the couch facing forward. She was shot in the side of the head. Dustin couldn't have had Elwyn in his arms, taken a step back, and then shot.
Lady, I'm sorry we have to do this a lot today, but this lady is infuriating me. You keep ruining your own theory again. You have the couch. Then you have the lady sitting in it. You have the kid in her lap. That's a weird kid. No matter how far he's away, you have the guy standing over here with his pew-pew. If he's grabbing the kid, or if he is not grabbing the kid, he already holds the kid. How does he pluck her in the side of the head in this position? She must have had her head turned like this. Or else it would make more sense to say, well, he stepped up next to her and just clocked her in the head. It makes no sense. Can you hear your own story? He's in front of her. She's looking at her, but she got hit here. Yeah, how did she get hit there? It sounds, to me, I'm sorry, it sounds like a deliberate execution. That she was sitting with the child. He walked over. They were fighting. He grabbed the gun, walked over. If he pulled the kid back and he didn't hold the kid in his arm, wouldn't it be more, if you're on the side of me, I'm holding the kid in front of me, you take the kid out and you just plug me in the head before I can react. General rules are you can talk shit about Baker and Brandon, no one else. Yes.
If he had done that, she would have been shot in the forehead from the front. Instead, what happened, what the evidence shows, is that Dustin was grabbing Elwyn's collar with one arm and shooting with the other, while Caitlyn was still confining and restraining Elwyn. It's the only thing that makes sense with all of the physical evidence that which was presented to you and that which was not and which was not tested. It's the only thing that makes sense with the location of the gunshot entry wound and exit wound. It's the only thing that makes sense with the trajectory of the bullet down through the drawers. The state's got it wrong when it describes where Dustin was and where Elwyn was when the shot was fired. The evidence that the state presented about what Elwyn says happened also gets it wrong. It's also misleading. The only evidence the state presented about what Elwyn says happened comes from a doctor, not from a police officer or an investigator. Let's go over exactly what Dr. Robertson said. Dr. Robertson was leading Elwyn. She was asking her pointed questions, trying to figure out whether she had any medical issues, based on the only information the doctor had at the time, which was that Dustin shot Caitlyn. Dr. Robertson did the best exam she could with that limited information. Dr. Robertson said that she asked Elwyn if there was anything wrong with her, and at first Elwyn said no. And only after Dr. Robertson guided her, led her to the answer, did Elwyn eventually say that her ear hurt and pointed to her left ear. Dr. Robertson had to ask her a very specific question to get that answer. She had to ask her how her ear got hurt. And Elwyn answered that question. She said, Mom and Dad were fighting, and Dad hurt Mom and me, and there was a lot of blood. And Elwyn's ear hurt because she had heard a gun that Dustin shot. That's not up for dispute. But think about what Dr. Robertson didn't know to ask. Dr. Robertson asked Elwyn if she was hurt anywhere else on her body, and Elwyn said yes. But Dr. Robertson didn't know what else had happened. She didn't know that Caitlyn had grabbed Elwyn, yanked her, pulled her, twisted her, made her scream in pain.
Neither do you, because no one said that.
Information out of Elwyn. The doctor didn't know what questions to ask to help Elwyn explain why else her body hurt. Elwyn was just 4 years old, and the doctor, who didn't know everything that had happened, couldn't ask her the right questions to get the full story from her. The state didn't have Elwyn testify. They didn't present testimony of any police officers or investigators who had spoken to Elwyn. They didn't give you the full picture of what Elwyn said.
Neither did you.
They gave you one small glimpse from a doctor who was there to treat Elwyn, not to interview or investigate. And the doctor didn't know what had happened and didn't know what to ask. You didn't hear the full story of what Elwyn said.
Refresh.
The state also presented evidence in a misleading way when it cross-examined Dustin. It tried to suggest that Dustin never told the police that Caitlyn threatened to take the kids. But Dustin told the police over and over again that Caitlyn threatened to take the kids. You have Dustin's statements to police in evidence. And here's the rough timestamps for all the times, not all, but some of the times, when he tells the police that she threatened to take the kids away from him, both before the incident and during. 28 minutes and 13 seconds, he says, she just kept threatening, well, okay, I'm going to take the kids away. 28:47, he said, every month it was basically the same thing of her wanting more money with threats of taking the kids away. 31:11, he said, she was basically threatening to put me in prison and take the kids away. 32:39, she threatened to arrest me and take the kids away. He starts discussing the day of the incident. 59:18, she started getting more and more aggressive about how, no, I'm going to take the kids from you. An hour and 16 seconds. The one thing that does set me off is these continued threats of taking the kids away from me. An hour, 1 minute, 58 seconds. Her just again threatening to take the kids and saying she just wasn't going to leave and that she wasn't going to leave and that she was going to take Elwyn and Valen back to Minnesota. By an hour and 32 minutes into this interview, he said it so many times that the police start talking about how she's threatening to take the kids away. Dustin told the police, and he told you, that she threatened to take the kids away over and over and over again because that's what happened. I've given a lot of timestamps, but I'd ask you to take a listen to the video around 1 hour and 40 minutes. That's when Sergeant McLaughlin asks, and I'm quoting, "The training you're talking about is marksmanship training, not specifically hostage? Because that's my first thought, was you're trying to remove Elwyn from a harmful situation. Do you have training in hostage-type scenarios?" That's the investigating officer's first thought, that Dustin was trying to remove Elwyn from a harmful situation and wondering if he had training in hostage-type scenarios. That was the police officer's first thought, because Dustin was trying to remove Elwyn from a harmful situation, from a hostage-type scenario. Think about the evidence that the state didn't present to you. The state didn't call Brenda. The state didn't talk to you about or present evidence of testing of the hair stuck in the slide. The state didn't ask the medical examiner about how hair impacts gunshot residue.
Why didn't you call all of these people? Oh, you did. Did they change the story, or you asked these questions and it didn't change the story? Because it's easy to stand there and say, well, I didn't call them because it's not my job, but that's reasonable doubt. But you could finish all of this, give the jury a clear indication that, well, that's not how gunshots work. Lady, get over it.
The state didn't have a police officer who spoke to Elwyn testify. The state had Dustin's phone. They had his text messages with Caitlyn, his text messages with Lori, his text messages with Rob, but they didn't show them to you. They didn't want you to hear what they said.
Always.
Those
Always
text
only
messages prove that what Dustin told you is true.
Objection.
Prove that what Dustin told you is true.
Objection.
They didn't want you to hear what they said. Those text messages prove that what Dustin told you is true.
So why didn't you produce those text messages so you could show that your witness is believable? Oh, because it was triple hearsay. Oh, that's why. Yeah. Because it's not, again, sorry, when I said in the beginning we shouldn't hate defense lawyers because they're just doing the job that they should do to protect people and make sure the legal process is okay. This lady has now misrepresented multiple times, directly lied multiple times, and done that shitty thing where she says, well, the other side lies all the time. I'm the only truthful one. I don't like her. I despise her. This is sidebar number 3. Yeah, because she doesn't have to, but it would just be nice when it proves that he is not lying. Just pick out that text message where he said all of this. Maybe that could circumvent the little bit problem with him not calling the cops, him calling his mom, hoping she would call the cops, then going black so he could make sure his kids were mentally fit before he turned himself in. Because that's the thing you do. No. I haven't seen that either. Well, Diane G, everyone on this channel always agrees with me. Except Sue, but Sue's wrong all the time. Except when she agrees with me. Well, I don't. Well, this, yeah, I despise this defense and the guy yesterday. Murder is like a chocolate cake. ¿Cómo? Yeah, I dog whistle all the time, just as Twisted Tragedies. Oh my God, I went in to see Twisted Tragedies react to Aiden having his charges downgraded yesterday. He's gonna fall. Just wait. Just wait. He's gonna fall within 5 days, within 10 days. Things are gonna come out. He's gonna fall. He can't keep getting away with it. Oh, those dastardly kids. Without them, I would have gotten away with it. But she wasn't having a great day yesterday. So, but how the hell does this woman has 105 people watching her? She says nothing for 3 hours other than Aiden is a bad guy. Everyone on the internet are psychopaths unless they are in her chat and gives her monies. I don't understand. I know some of you are dumb enough to watch my content, but still, you have to be especially dumb to watch hers. I only hate watch Baker, and I only hate watch allowing you to be here. I wouldn't have accepted this super chat from anyone else but you because I am going to use these $5 to buy my Lord, which I hate. So it's going to be hate. Hate is all around us. It's everywhere we go. Hate is all around us. It's like sweet and snow. Yeah, this is probably not the masterclass in doing closings. I think one of the worst closings I've seen so far is Hanky Panky because it was so low energy and him just sitting down in the end and people were like, oh, he's done now. But this lady is absolutely redonkulous. The best viewers do. Watch Twisted. Favorite thing yesterday was Twisted telling Nan how to be a lawyer. Let's just agree Nan shouldn't have shared that voicemail with the phone number. She should have beeped out the phone number. When I played it this morning, I muted. So no reason to dox this lady. She's in enough trouble as it is because she listens to Twisted Tragedies. But the weird thing is these... Stop going to Krusty Panties and Twisted to get legal advice. And why would you call Nan and ask for her as a lawyer if you don't even know if she does this type of legal work? Only an idiot would do that, but hey, I'm repeating myself. This was a clear setup to try and have Nan go in and take this case because of the JFK crew against Aiden. She's probably mad, so she's going to hate him. That's ridiculous.
Members of the jury, based upon the state of the evidence, I am going to strike the last sentence of the defendant's closing argument and instruct you to disregard it. Thank you.
I expect the state is going to try to argue that Dustin didn't reasonably believe that Caitlyn was committing or about to commit a kidnapping because she was the children's mother and because there was no court order on custody. But that just doesn't make sense. Think about it. Imagine if Caitlyn's secret plan had gone into effect. Dustin would have woken up in the morning to both of his children gone, stolen, kidnapped, taken away to another state.
But he didn't know it. He had no knowledge that they were going to be kidnapped. So how can he defend against a kidnapping he didn't know about? Because bear hugging someone in a couch is not a kidnapping.
We are talking about unlawfully taking children away from their father to another state permanently without him knowing. We are talking about coming up with a secret plan. We are talking about deception. We are talking about Caitlyn planning to commit a crime. Dustin reasonably believed that Caitlyn was about to commit a kidnapping. And the fact that she's the children's mother doesn't change that. The state's also got it wrong. They're missing the point when they spend hours and days focusing on cell site location data and testimony from someone who saw Dustin's car and presenting a whole lot of evidence of things that aren't in dispute, that Dustin told you happened. They're focusing on what happened after the shot was fired. But what matters in this case is what was happening immediately before and while the shot was fired. This whole case is about Dustin's defense of Elwyn, that Dustin was justified under the law. Dustin wanted to spend more time with his girls. That's not a crime. He's not charged with anything related to that. It's only human nature. It's a father wanting to make sure his kids are okay. He wasn't denying what had happened. He called his mom and told her. He knew his dad would call the police. He made sure they knew the girls were okay, and he told them that after he took some time with the girls, he was going to turn himself in. He didn't deny what had happened when he waived his right to remain silent and spoke voluntarily with the police. And he didn't deny what had happened when he took the stand here yesterday and spoke to you. Nothing that happened after the fact changes what happened in that apartment. It doesn't change that Dustin reasonably believed that Caitlyn was about to commit a kidnapping, that Caitlyn had a kidnapping plan, that Dustin was justified under the law. The state is wrong about whether Dustin's use of deadly force was justified. Think about Dustin's perspective. Think about what was going through Dustin's mind at the time. Dustin didn't think there was any help available. Dustin had spent months trying to figure out how to deal with Caitlyn. He called his parents. He called her parents. He called a lawyer in Minnesota and one in Vegas. He called the Berlin Police Department, and they told him they couldn't help. Think about that time a year or two ago when he called the police in Vegas, and they didn't show up until after the threat was gone. Think about the fact that Caitlyn had kidnapped his child before.
That was a home invasion, allegedly. Again, you're talking about a man banging on his door versus a woman sitting in a couch holding her baby. I didn't trust the system because they didn't show up till after a home invasion where I didn't call them till after the people left. I spy Bob Belcher's ball spot. That's a hard word to say. Who's Bob Belcher? But thank you so much, Diane J. No, that has everything to do with a home invasion. This lady.
And she had a plan to do it again. The judge will instruct you that you should consider how Dustin acted under the circumstances as they were presented to him at the time, and not necessarily as they appeared upon detached reflection. Consider how he felt at the time, in that moment that Elwyn is screaming in pain. Consider his perspective as a Marine, his perspective as a father whose child had been kidnapped before by the very same person who was holding his child hostage in front of him. And I'd imagine the state is going to talk a whole lot about other things that they think Dustin should have done instead. But think about what's going on here. Dustin tries to de-escalate the situation. He tries to talk to Caitlyn. She won't talk to him. He begs her and pleads with her to just let Elwyn go. And she refuses. He tries to just grab Elwyn. And Caitlyn won't let him. He begs again for Caitlyn to let Elwyn go. And she refuses. He tries to get Elwyn a second time, a third. And the third time he tries even harder, grabbing Caitlyn's wrist with one hand and trying to pull on Elwyn from behind. And it is only once Caitlyn physically harms Elwyn, only when Caitlyn is willing to go to the length of letting her child be harmed, be hurt, to enact her kidnapping plan, that Dustin acts. Even when Dustin grabbed the firearm, even when Caitlyn heard him chamber a round, she still didn't let Elwyn go. Even when Dustin pointed the firearm at her, Caitlyn still didn't let go of Elwyn. Caitlyn was still holding Elwyn hostage even after he had taken those steps. Those steps of grabbing the firearm and chambering it weren't enough. So Dustin did what he had to do. Dustin reasonably believed the amount of force he used was necessary because nothing else worked. And again, you will be instructed to think about Dustin's actions under the circumstances as they were presented to him at the time, when he acted in the heat of passion. Consider the stress, the anxiety, the fear, and the need to take immediate action, to prevent Elwyn from being hurt, to make sure Elwyn was safe. Your role is not to Monday morning quarterback. It's to think about what Dustin was seeing and thinking and feeling in the midst of this horrific situation when he had to make a split-second decision and act instinctually. And from that perspective, Dustin did what he had to do to save his child. Dustin was justified. Think about the fear that Dustin felt, hearing Caitlyn tell him he was never going to see his children again, seeing Elwyn restrained, confined, held hostage in front of him. And think about the fact that he did not take that action until Elwyn had been harmed, until Elwyn screamed in pain and locked eyes with him, until the line had been crossed. He was a Marine and a father, responding to a threat. He was a Marine and a father, protecting his beloved daughter. This is a tragedy, but it's not a crime. When you hear from the state,
he knew the kidnapping law written into the self-defense laws after he did it. That's why he never mentioned kidnapping in his interview, only until he read the statute just like you did and said, oh, fuck it, I'm going to use that as my defense. That's how most of these super geniuses figure out which state to do it in. They'll find the thing that fits their story and they'll say it. It's not something they think of first.
I ask you to keep in mind everything we've just talked about. I ask you to keep in mind that Caitlyn's own aunt told you that Caitlyn had a plan to kidnap the kids. Keep in mind that if Caitlyn had a plan to kidnap the kids, it was reasonable for Dustin to believe that she had a plan, that she was about to kidnap the kids. Keep in mind that the law says that Dustin had the right to use deadly force if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. The judge will instruct you that you must apply the law and that you must hold the state to its burden. When you do, you will return the only fair and just verdict, the only one supported by both the evidence and the law, one declaring Dustin Duren not guilty.
roughly 1 hour and 5 sidebars. You will see this if you go and see Kelsey Fitzsimmons, the restraining order, the motion that they filed, the fiance filed. They will read what is necessary to get this restraining order, and then they will say, I'm in fear of my life, and they will use exactly the words that's there, just so the judge will read it and say, yep, it hits all the basic tenets that it needs to get an RO, and you'll get an RO. Boom. That's how they do it. It's the same when defendants are sitting there saying, I don't know, can we go with self-defense? Why? Well, I was afraid she was going to take my kid. Again, I bet if he had said, I acted in the heat of passion, I was enraged, she was threatening to take my kids, my life, everything, he would get less time in prison. He could maybe even get it down to manslaughter. It would have been a better defense than there was some kidnapping plan, and as a Marine, I'm trained to go into code red and just hip fire into the face of someone holding a child, because yeehaw, Semper Fi.
I'm just ready to take a
He didn't.
That's fine, Your Honor. I'm ready now or whenever you'd like.
Break for 10 minutes. He didn't have a gun on him. He went to a drawer, according to him, in a side table, took it out. Never ever, he's not a guy who keeps one in the chamber. So he racked it. That's apparently when that hair got in there, maybe. Then he hip fired into the side of her head while holding his child away from her, because that's a safe use of a weapon. He is a trained marksman. Well, he's a shooting instructor, but he chose to do that hip firing thing while holding his child because that's absolutely safe. That's what any Marine would do in this situation, especially with an unarmed sitting woman. There is no other way to react than going and pew-pewing someone in the face because they are bear hugging your kid, and while you are struggling to try and grab the kid from them, they turn away from you. There's just no if anyone, we are 153 people on the YouTubes, and we are 7 people on the Rumbles. So 160 people, if we can get together and make our massive brains work, could there be any other way a trained, unarmed combat Marine, who is a rifleman first, could have prevented his sitting 114-pound wife from kidnapping his children, other than just pew-pewing her straight in the face? Nothing comes to my mind. Because remember, he was in defense mode because this lady who had never been in this apartment, she might know that he had some knives in another room. Have you thought about that? And there were lights outside going past. He didn't know who's going to show up. There is no way other than you have to shoot. It's a shoot-only situation. Who's tiny? I don't know. Anyone tiny? Oh, who is tiny? Yes, yeah. 114 pounds, 5 feet tall. This guy who was 6'2", I believe, I just can't see any reasonable way he could have done anything to prevent this from happening. Nothing. Do they get stripped of military credential when stuff like this happens? I don't know. I don't know how you do it in America, but it has nothing to do with your service, so you shouldn't lose anything. If he hasn't been an active Marine. He's been out since 2011. He then played music and went to music school in California, where he was the greatest musician in the world. That didn't really work out. He was so good, even the teachers wanted to play with him. It didn't really work out, so he went back to school and became a sound engineer. He was the greatest sound engineer in the world. Instantly, he got hired to work for Fox Sports, I believe it was. Moved to Las Vegas, where he got robbed and hit rock bottom. And then he met the victim in this case and had a child. And then, well, that's back when he still updated his WordPress. He then had multiple YouTube channels and worked as an independent sound engineer successfully, because he is the greatest sound engineer in the world. What we didn't hear is right after all of this, he found out he had PTSD, so he couldn't work, because he also used to be a postman. Because having multiple YouTube channels doesn't mean you have multiple revenue streams from YouTube channels, because most channels don't make any money on YouTube. So he probably had a lot of, I'm so smart, I can make music. No, you weren't. Thank you so much, Brandon. A hundo. It's because on Tuesdays we do curls. If you want abroad giving you a Portuguese snowblower, that's why you get pink eye, Brandon, because you get the Portuguese snowblowers. For anyone who doesn't know, it's Colombian product and then while you're getting to know MG's sister as she's firing up the lawnmower, your biceps better be dread-free and effing swole. Brandon, Mod of the Year there as well. Where is, what's a Sue bird? That's a Sue bird. Thank you so much, Brandon. Now, have to get the sponsor banner on as always. Thank you so much. And again, I'm just saying your pink eye most likely stems from your Portuguese snowblowers. Stop doing that and you won't have all the pink eye. And I don't think, like when you're saying, well, I got it from the toilet, I don't think your wife believes that, well, I was at the pool and it just blew into my eyes. Hey, Cindy Lou Hoot. Yeah, you just missed some of the worst defense closings in histories. Hey. Oh, what did I call you yesterday? So something. McLaurin. Gluten. I can't remember it now. I said I would forget your new nickname. He could wear safety glasses. Brandon, consider that the next time. That or the compromised immune state. I believe it's I'm not saying that you might need to upgrade your bed companions, but again, if you go for the $10 ones, you have to play. It's the roulette. The pink eye will show up. Go back and watch the defense. They had 5 sidebars. That's all I can say. Yes, they did 5. Can you tell Brandon what a Sue bird is? He's asking. Should it be gluten McTootin because I don't eat gluten? So it's good. Should be gluten no tootin. Yesterday I said it was like when Jacob imprinted on Renesmee in Twilight. Whoa, I am vibing with that small child. Are we gonna kiss? Don't kiss small children. That's weird. See, Brandon, that's a Sue bird. Have I ever met someone who doesn't eat gluten and keeps that information to themselves? I don't ask many people about their dietary habits, but I would say vegans are worse. Vegans will always tell you, or CrossFitters and vegans, because I think a lot of vegans became CrossFitters, but they will tell you. Don't drown Sue. That's my end game. Surely you aren't that selfish. I'm not going to drown Sue. Sue is she is my release valve, because every time I get mad, I can always make Sue mad, and then she'll yell at me, and then I can yell back at her. He we have it as well, and my ex-wife all of a sudden became gluten. Yeah, you didn't bring it up. I brought it up. Guess I'll go home and watch Twilight. Go home and watch something good instead. My ex-wife all of a sudden became gluten intolerant as well, because she was reading that's the new thing that makes all your problems in your life. How she hasn't changed her name, what's it called, numerology or whatever, yet, I don't know, but something must be the reason, because it can't be her that her life is like it is. So she became anti-gluten because she couldn't dairy and gluten. She couldn't handle that. And then we went to my daughter's graduation party, and I had baked a cake with gluten and dairy. No problem. No problem with that cake. None whatsoever. It's funny how it works. If you put enough sugar in with gluten and dairy, it'll kind of, for some people, it'll just mellow out the gluten intolerance. That's a good thing. I get to yell back. Well, I try, but then other people start yelling at me because Sue is apparently sacred.
I remain standing for the honorable jury.
Celiac is somewhere between 0.5% and 1.25% of if you go around the globe. They are the best people. And when you say, oh, next time I'll make them gluten-free. No, these are fine. It must be because I've had a good diet this week. I don't care. I make cakes for them to be eaten. Yeah, have you tried it?
Thank you. Please be seated.
I'm gonna go story time. Back when I was a baker, they started with the gluten-free because yes, some people are celiacs and it's horrible for them. And they started making these gluten-free breads, and we couldn't do them as bakers because we didn't know what the hell that was. So we just used the shake and bakes that everyone could buy, and then we sold it, marked it up to twice the price. But hey, people are dumb enough to buy it. And it's the most disgusting thing I've ever made. These days you can get good products, but back then it's kind of like the faux meat, the fake vegetable meat things. Some of it is okay. I've eaten some of the burger patties because they're so filled with fat that it tastes good. But most of that is so horribly. And I'm thinking, when people have a desire to try something else, make the product good. It's just shitty.
And let the record reflect, I'll be moving to adjust.
I do make some coconut tops where it's just shavings, coconut shavings, egg whites, and sugar. I made them on the channel before. Maybe I should make them again because Brandon needs a cooking stream.
My position where I can maintain visual contact. Attorney Duren, you ready to proceed?
Thanks, just checking, you're all set?
Yes.
Ladies and gentlemen, this was not an accident. This was not defense of others. This wasn't done to prevent a kidnapping. It was murder. And he knows it. He knows. And that's why he's changed his story over time. He's taken time to craft what he's wanted to say. It's why he has changed what he told the police after he was caught to what he testified to on this stand. It's why he's tried to blame Caitlyn Naffziger for her death. The real victim here, the victim that you're here to decide this case about, is the unarmed woman who the defendant shot in the head, who was sitting on the couch with a child. You know, yesterday, when he testified towards the middle of his cross-examination, he told you, in his own words, live from the witness stand, why he shot and killed Caitlyn. And he told you that in that moment, right before he got his gun, right before he pulled the trigger, that she hurt his daughter. His daughter. If you listen to defense counsel's opening, I lost track of the number of times that they described this child as his daughter. Caitlyn Naffziger, according to the defendant, hurt his child. She hurt her by holding her tight, hurt her by pulling her close, hurt her by pulling the child away when the defendant tried to grab her. Turning it on helps. Let's be clear. Caitlyn was holding their child, her child, as much as his. A child she carried for 9 months, a child she gave birth to, a child that she could hold and bear hug and be with just as much as he could. They had equal rights to these children, rights they had been arguing about since August of 2023. On the day that the defendant killed Caitlyn, he was angry. He was yelling. He didn't want to admit that during his testimony, right? I maybe yelled 1 to 2 sentences. The defendant needs to be in control. That is clear from his testimony. It is clear from his statement to the police. He is the person who operates best under stress. He needs to be the leader. He wants to have a plan, and you know what? Once a plan is made, there are no changes. Plans never change. But on that day, on February the 29th of 2024, the defendant was not in control of Caitlyn. You know, defense counsel stood in front of you and said, think about how he felt, that he might have to lose his children, that he couldn't hug them when he was taken into custody. He was asking Caitlyn to drop her child, the youngest one off, their child, with him, to then see her daughter, their daughter, who she hadn't seen in a month, month and a half, sleep over and leave. Think about that day and what the defendant's behavior must have been. How his frustration over the situation, over the change in plan, turned to anger over the course of a day. It must have. It doesn't make sense that it wouldn't have. He didn't want Caitlyn there in his apartment. He wasn't happy that she had spent the night. It wasn't part of his plan. He wanted her to leave. He testified and told the police that during that day on February the 29th, every 15 minutes or so, I think he said 15 to 30 on the stand, but he said 15 during his statement to police. Every 15 minutes for several hours, up to 5, he agreed with me yesterday, probably between noon and 5 p.m. He went to the room where Caitlyn was playing with their daughters, and he asked her when she was leaving. He hovered in the doorway. Her being there wasn't part of his plan. He wanted the girls with him, and he wanted Caitlyn gone. He told the police that. He told the police that he'd even discussed it with his mother. For at least 5 hours, every 15 to 30 minutes, he went to that doorway and he said, when are you leaving? He asked how she was leaving. When is her ride coming? And she was ignoring him. She wasn't ready to leave her children, their children, behind. The defendant was frustrated, but he became angry. He was angry because she wasn't doing what he wanted, wasn't following his plan. He was angry because she was ignoring his questions, because she didn't want to leave. He was angry because they were having the same dispute they'd been having since August of 2023. And Caitlyn, we know, apparently, didn't want to hand their 4-year-old daughter over to the defendant while he was yelling and angry.
Kennedy, on this channel, I have a very, very tough stand against trying to imply any sexual assault on kids. There is no proof that he's grooming this daughter for anything. please refrain from implying that, because no one has said it in this trial. I am very, very against anyone claiming it, because it just takes one rumor to get a step fire going. And I had the same in the Carly Clegg when people started saying he was banging his daughter. It's a very serious allegation with no proof so far. He might have had a very unhealthy relationship with his kid, but grooming is a step above most other allegations. So please don't, unless you have proof of it, don't start these rumors.
While he was pulling at the child and trying to yank her from Caitlyn's arm.
Well, Booz, I have a very strong stance against spreading any theories about that without any proof, because it's such a horrible rumor to start about a man if you don't have proof that he's doing it. It only takes one rumor to start a step fire, and you don't want that. I had the same stance in the Carly Clegg channel case, where other people said he was banging his daughter, and I don't condone people just making up those allegations without any proof, because it's a horrible, horrible, horrible thing to claim. He had a very unhealthy relationship with his daughter. I have seen no evidence that he in any way had a sexual attraction to her.
Caitlyn knew how angry he was, and she knew that he was dangerous. She didn't know how much of a danger in that moment, but he'd show her. You know that Elowen told doctors at the hospital what happened. You know that she asked them to look at her ears because they hurt from the loud noise of the gunshot. Defense counsel wants you to believe that Dr. Robertson, somehow not knowing what happened, led Elowen to make the statement that she made. That simply doesn't make sense. You heard testimony from Dr. Robertson where she explained to you how she approaches a child. Hi, I'm Dr. Natalie. Can you tell me what hurts? That's not leading. That's not trying to get an answer from a child. It's trying to find out where they hurt and where to examine. And when Elowen was asked what hurt and where to examine, she said that mommy and daddy were fighting. She said that daddy hurt her and mommy, that mommy had lots of blood. Elowen didn't have any bumps or bruises from being held tight by her mother. She didn't say that mommy hurt her. She said daddy did. The defendant hurt them both, and he hurt them in the worst way possible. On February the 29th of 2024, Dustin Duren murdered Caitlyn Naffziger. He killed her as she sat on a couch in his living room. Remember the testimony. And ladies and gentlemen, you are the deciders of the facts, right? If defense counsel stands in front of you and they tell you something and you disagree with it, that's what you should do as jurors. You're the judges of the fact. If I stand in front of you and I say something that you don't agree was the evidence that you heard, that's what you should do. You should discard what I tell you and pay attention to the facts that you heard in testimony. But the facts that you heard was testimony from Dr. Weinberg, right? And he talked to you about close contact firing. And even under cross-examination, his testimony was that the defendant had to be 3 feet away or more from Caitlyn. And not just the defendant, right? But the tip of the gun.
Keep your finger off the
Tip of this
trigger.
gun had to be.
No matter if it's loaded or unloaded, keep your finger off the trigger.
3 feet or more away from Caitlyn's body, away from her head when it was fired. And so we know that the defendant stood at a distance when he shot her in the side of her head. When Dustin Duren fired a single bullet from this Beretta 9mm handgun, Caitlyn Naffziger was wrapped up on the sofa in their daughter's pink unicorn blanket. Her foot was on the coffee table. She had no shoes on, and there were none close by. She wasn't threatening anyone. She had no gun, no knife, no weapon of any kind, nothing. She wasn't even looking at the defendant. You know, defense counsel stood in front of you and said, well, if it happened the way the state described, well, then Caitlyn would have been shot in the head. Well, not if she wasn't a threat, not if she wasn't watching him, not if they weren't engaged in any kind of dispute or argument like the defendant has said. We know from the evidence that she was shot here, in her temple. That's what the doctor can tell you. In terms of positioning, that's based on how they were interacting at the time, and Caitlyn wasn't looking at Dustin Duren. The defendant's bullet entered the left side of her head at her temple. It traveled straight through her brain. When the bullet exited on the right side of her head, it took pieces of her skull with it. The bullet continued in a straight line, cutting into the built-in bookcase behind her, ricocheting through the drawers. You know, Caitlyn was likely dead before Elowen even saw the blood, before Elowen began screaming about the noise of the gunshot hurting her ears. The defendant didn't check to see if Caitlyn was alive, to see if she could be saved. Instead, he ran. He loaded his car with changes of clothes. More than he needed for one night, more than he needed for two. He put his desktop computer tower in the trunk. He turned out the lights, he turned the key in the deadbolt and locked the door. He drove south. He went dark. You know, defense counsel made it a point that you didn't need to know about his phone searches or his phone records. You know what they told you, those records? They told you when he left his house, which gives you an idea of when he killed Caitlyn. Those records that you have in evidence show you that around 6 o'clock, between 5:30 p.m. and 6 p.m., on the 29th of February, the defendant began to leave his home. Caitlyn was dead, and he was on the run. A person who's justified, who acted lawfully, who acted to defend someone, they do not run. They stay in place. They do the right thing. They ended the threat. They call the police and they tell them what has just happened. It's the first thing that they say. They yell it at the top of their lungs. They scream that they had no other choice. But the defendant didn't do that, and he didn't do that because he had choices. There were options that didn't involve putting a bullet through an unarmed woman's head. He knew then that what he had done was not justified. It wasn't in defense of someone else, and it wasn't to stop a kidnapping. It was a murder, and he acted like a murderer. You know, a murderer packs their clothes and drives through the night with 2 little girls after he has killed their mom and left that mom dead in his living room. A murderer turns off his phone so the police can't find him. A murderer needs 16 hours to tell the police that something happened. And that's how long Dustin Duren had. From 6 p.m. or 5:30 p.m. when he left that house until he was taken into custody at 10:30 the next morning, he had 16 hours. But you know what's even more is a murderer needs 3 hours of background testimony at a trial before he can tell his new version of what happened.
Can I have your coach?
What's the problem in what she just said? I don't know what Brandon, I wouldn't beat Brandon because of you, Sue. There's a lot of other reasons, but not because of you. You can handle your own beatings. Yeah, he only wanted to go to brunch first, and then he wanted to turn himself in. I really don't understand why. What are they going to argue? She didn't say anything that was wrong. And again, yes, this has been a good state closing because she goes to the facts. I think it's really important to say it was a close contact and it was a straight through and through. So he must have been holding it. His whole "I was shooting from the hip" tax doesn't work. It's not an angry look. It's more my, do I have constipation or am I wondering face? He has a Fifth Amendment right to defend himself on the stand. That's the only wrong thing she said. Yeah. Oh, that was overturned.
A murderer needs 1.5 years to explain that his actions were an act of defense of others. You know, ladies and gentlemen of the jury, The defendant thinks in this case that he can fool you, that he can put this claim of defense of others in front of you, and that you will jump on it and detract from his actual actions and his intent.
The kid is 5, maybe 6 years old. It wouldn't have been a believable witness.
When you were chosen as jurors in this case, each of you individually, you brought your life experience with you. You brought your ability to make assessments and to make judgments, and you brought your common sense. You know, we keep a lot of things that you're not allowed to bring with you into the courthouse or bring with you into the jury deliberation room, but your common sense isn't one of those things. Your common sense and your knowledge about people, it stays with you when you come in the courthouse. It stays with you here in this courtroom, and it will sit with you as you go into that back room to deliberate. Your common sense and your experiences is why you were selected. And it gives you a framework and a basis to evaluate what happened on February the 29th of 2024. This is a framework that you can use to evaluate the witnesses, the testimony, and the evidence. Your common sense plus that evidence and plus the court's instructions are the tools that you have. They're the only ones we give you, but they're the tools that you have to fairly and impartially weigh the evidence in order to determine whether the state has proven beyond a reasonable doubt in this case that the defendant killed Caitlyn Naffziger, and that when he did that, he was not acting in lawful defense of others to prevent a kidnapping when he shot her in the head. You, as I've explained, are also the judges of fact, and that is why you use your common sense to evaluate that testimony. You give the testimony of each witness what you believe it deserves, not what the state tells you and not what the defense tells you. In terms of the first part of your job, determining whether the state has proven beyond a reasonable doubt that the defendant killed Caitlyn Naffziger, at the beginning of this case, we stood in front of you, my colleague, and told you that this is not and would not be a complicated finding for you. This isn't a whodunit, that by the conclusion of the evidence here, you would know beyond a reasonable doubt that the defendant is the person who shot and killed Caitlyn Naffziger. Throughout the past week, you have learned that he confessed to his parents, he confessed to the police, his gun is the murder weapon, that he knows that when you point a gun at a person, you intend on killing, that he knows exactly where the bullet went, and that he has testified now in this case that he is the one who fired the shot. You know beyond a reasonable doubt that he killed Caitlyn Naffziger. The defendant is facing several charges related to this case. Those charges include second-degree murder, reckless conduct with a deadly weapon, and endangering the welfare of a child. The judge has explained some of the law to you, and shortly he's going to explain to you what it means to commit second-degree murder. The defendant, to be clear, is charged with 2 variations of second-degree murder. He's charged with knowing second-degree murder and reckless second-degree murder. The difference is in what he was thinking at the time that it happened. The court will talk to you about those charges of reckless conduct and endangering the welfare of a child, and those charges, so that you understand, are related specifically to the defendant's actions in which he placed 4-year-old Elowen in danger or violated a duty of care that he had to her. The facts of this case as presented to you over the past week and a half, have demonstrated that each of the requirements that you need to find the defendant guilty of these crimes beyond a reasonable doubt have been met. Let's demonstrate what I'm asking, or what the state, what everyone's asking you to do here. I want to look at the factors of second-degree murder. Up on the screen you have in front of you part of what the judge will instruct you on. The judge is the judge of the law, just like you are the judges of the fact. So his instructions will hold, okay? Now you have to decide whether the defendant caused Caitlyn Naffziger's death. Again, this has been proven. The defendant admits that he was the person who pulled the trigger, that he shot Caitlyn in the head. He caused her death. For knowing second-degree murder, you also have to consider whether the defendant acted with a knowing intent to cause her death. That means that when he fired the gun, he was aware that such conduct would cause Caitlyn's death. You should consider all of the evidence that you've heard throughout this case when you decide whether the defendant knew that he would cause Caitlyn's death by shooting her that day. You've heard about the defendant's ability with a gun, his military training. He testified that he raised the gun, and he admitted that the purpose of pointing a gun at someone is to kill. There is no other purpose. He knew that this would be the result when he pointed his gun at Caitlyn and when he pulled the trigger. He knew exactly where the shot would go and the damage that it would cause. For each of the charges that we're talking about, you must also consider the defendant's claim that he was acting in defense of others. Specifically, the judge will instruct you that in this case, acting in defense of others means that the defendant had to not just reasonably believe. Now, defense talked to you in their closing about reasonable. It was a reasonable belief, a reasonable belief. But you'll note that on the screen, and as the judge will advise you later, that there's actually another portion of that. The defendant's belief has to be an actual belief and a reasonable belief. We expect and anticipate that, the defendant testified from the witness stand that all he had about this kidnapping plan or kidnapping idea were his suspicions. Suspicions are not an actual belief, they're just suspicions. The defendant didn't have an actual belief here, and he didn't have a reasonable belief here. And if he didn't have those two things, if his belief wasn't actual, if his belief wasn't reasonable, then he was not lawfully acting in self-defense, and his murder of Caitlyn is not justified. There was a lot of discussion about where Elowin, where the 4-year-old is at the time that the defendant fired. And that's one of the things that you can consider, both in the charges of reckless conduct and with respect to the defendant's claims. At the time that the defendant had fired, if we look specifically at his claim that Caitlyn was kidnapping, right? At the time that the defendant had fired, he had grabbed Elowin with his left hand, and he shot Caitlyn with his right. With that action, the defendant ended any argument he might have made that he had shot Caitlyn to prevent a kidnapping. It was over, it was done, and he had the child. But it's the state's position that there was never any kidnapping. Caitlyn was never about to commit a kidnapping. She was not about to do anything. She had made her position clear to him. She was refusing to leave, and she was seated on the couch holding their daughter. In the defense's opening statement, they told you that the defendant pulled Elowin to safety before he fired. He told the police in his statement that he had grabbed her, pulled her back, and then shot. But yesterday in his testimony, he stated that he had just pulled her forward by her shirt and held her in place. He implies that she was still on Caitlyn's lap when he fires the gun. But the defendant's testimony doesn't fit with the evidence. Dr. Weinberg testified that he found no evidence that the shot occurred within close range. He testified even on cross-examination that his opinion was that it had to be 3 feet or more away. He found no evidence of stippling. Now, this isn't gunshot residue, it's stippling. Little burns of gunshot powder embedded into Caitlyn's skin or face. She didn't have any. There was no stippling on Caitlyn's wound. There was no stippling on her face, her neck, or anywhere on her. Dr. Weinberg found no evidence of soot deposits on her face, and he testified to you that based on his examination of her body, the muzzle of the gun had to be at least 3 feet or more, not closer, 3 feet or further back when it was fired. And if the shot came from 3 feet or more from Caitlyn's body, there is no possibility that Elwyn is on Caitlyn's lap when the defendant fires. Elwyn was in his arms. Even if the defendant had fired the gun in the way that he demonstrated or tried to demonstrate from the witness stand yesterday, he would have been closer to Caitlyn than 3 feet. The gun would have been closer still. Just as he told the police, the defendant grabbed Elwyn and pulled her back. The defendant then had to step back to shoot Caitlyn Naffziger from the distance that her body shows the shooting happened from. Now, I want to talk to you a little bit about defense counsel's desperate efforts with respect to State's Exhibit 24A to talk about a hair on the slide. No one knows whose hair this is. No one. Defense counsel does not have to put on a case. They do not have to bring up evidence. But if this hair was the linchpin that solved it, they had every right and could have. And they chose to put on a case.
Objection, burden shifting.
That's actually correct. No, you don't need to approach. Just give her that because you're burden shifting, saying they could just bring it. I know I did it the same, but you can't bring it out in front of the jury. I can say it because I'm sitting here behind my screen and I'm not in the courtroom, but this lawyer is in front of the jury and she can say, well, they could just have disproven it. Yeah, just say sustained because it's going to take 5 minutes every time. And we do have a case in Wisconsin we need to get to figure out why a lady was half naked in a wood dead. Again, this is a sloppy close and the judge better do something. Yeah, this time it was a correct. The first time it was a wishy-washy, but apparently, not apparently, this time it was one. And if any of you are followers of the Karen Reed case or the Aiden Carney case, Betterow has just made a supplemental motion to produce evidence because Marbury v. Matt, as she is known on the Twit, had filed lawsuits to get materials from the Commonwealth that hasn't been produced. And apparently Proctor has also been acting in Aiden Carney's case, even though they have lied about it and there was no reason why Aiden should have his phone transfer, the over 100,000 files of phone data. And Betterow have now filed saying, well, clearly Proctor is being kept up to date on the Aiden Carney case and makes inputs on it, so we should also have access to Proctor's phone data. Plus, if any of the alleged nudes that could be on his phone, if any of those are real, he perjured himself on the bench. And if he had shared information, he could be facing a year in prison, Michael Proctor. I bet the Commonwealth will do whatever they can to try and say, no, he was just getting emails because it was a mistake that he was CC'd on everything. But that's an interesting little document that we might need to look at later. I just measured, I do have a rather square coffee table, so it's deeper than most, but exactly 3 feet from the front of the coffee table to the edge of my couch. Yeah, so he must have been on the other side, at least, of that coffee table. Remember, she was sitting and bracing against the coffee table while he was trying to pull the kid away. Which, again, he wasn't as close as his defense said. Dark Lotus, I agree. Every burden shifting is burden shifting, and the prosecutor should not do that. Well, you can't object to be grifting. Well, that's why I say body language, tool markings, and tea leaves are the same exact levels of science. Whenever you go to those channels who will tell you that they can read the minds of juries or witnesses or defendants in a case by just looking at the way they're twitching their nose, they're filling you with bullshit. They will do they're looking down. That means, yeah, everyone have heard that, but there's no way they can read anyone, because the big problem is, to be a real body language expert, you can be that. Body language reading is real, but you have to have a baseline, which means you would have to have studied this person under different circumstances. This is why people who are really good at poker, who reach the high stakes table finales, have a really hard time playing against each other, because they can read each other's signals, because they have seen them over and over and over and over and over and over again. Body language relies on repeated observations. You can't read anyone cold other than the basic, oh, he seems nervous. But he would also just have had Taco Bell the day before.
Members of the jury, I'm going to strike the
Yes.
last sentence from the state's argument. Two other comments. The defendant had no burden to test any evidence in this case. In fact, the defendant has no burden to produce any.
She was
evidence.
bracing.
So with those instructions, I'll allow the state to complete.
Thank you, Your Honor. Ladies and gentlemen of the jury, defense counsel kept showing you this photograph, the word hair, because there was a hair in the slide. And they want you to somehow put together and believe that that is Caitlyn's hair, because that would somehow show you and prove by their theory that the defendant was closer than 3 feet. That you should use the fact that there's a hair on the gun, a gun that was next to the defendant, next to his child, in a pocket inside of a door in a car, and that you should somehow use this missing hair that hasn't been tested to decide that that means he was closer. That you should use this hair to disregard the testimony, the evidence, and the expert opinion of Dr. Weinberg. That doesn't do this. There's no inference as to whose hair. You know, I think we all understand, especially possibly the women on the jury, that hair falls out. It's everywhere. Hair on a gun isn't an inference that you can make. It doesn't matter whose hair it was. None of it would show that Dr. Weinberg's testimony is called into question. Dr. Weinberg, who testifies that this gun, the muzzle of it, the very tip, was at least 3 feet away from Caitlyn when it was fired. 3 feet from here to Caitlyn.
Well, she was.
You can make reasonable inferences from evidence.
But she
You
kept her
cannot
finger
make
off the
jumps
trigger.
or wild conclusions. You have State's Exhibit 26B in evidence. That's the defendant's statement. This is an image from that, just showing you him in that room where he was interviewed, in that room with police officers on March the 1st of 2024. He didn't claim during this interview anywhere, at any time, that he acted to defend somebody, that he acted to protect Elwyn from being kidnapped. The defendant didn't shout it at the top of his lungs. He never once said he acted in defense of anyone. Unlike in his prepared testimony Friday of last week and yesterday, the defendant didn't tell the police that Caitlyn was kidnapping anyone or about to kidnap anyone. He also didn't tell the police about his suspicions or make hypothetical statements that someone might be outside of his apartment. He didn't tell the police that she was demanding that he pay her money in that moment. He talked a lot about times she'd asked for money in August of 2023, in September, October, leading up to this incident, but he never said those demands happened before he shot her. He didn't tell the police that she was demanding that he sell his car and give her money. He didn't tell the police that before he shot her in those moments, that he'd never see the kids again. These are all statements that he added over a year and a half later in support of his defense to excuse his murder of Caitlyn. You remember when he was specifically asked in that statement if Caitlyn was threatening anyone or causing any harm, he said no. He never once said he had to act to defend anyone. He never once mentioned a kidnapping. Not until yesterday in this courtroom did he make that statement. And even then, if you remember his testimony, he didn't say that he acted to shoot because his daughter was being kidnapped. He stated that he had shot and killed Caitlyn because in that moment, she was hurting Elowen. You know, the defense has argued to you that Brenda Plamondon and Caitlyn Naffziger formed some kind of secret plan to take the children. Their plan involved code words and planned 911 calls. And it never happened because Caitlyn never called. You know, for a plan to be secret, the people involved in it don't tend to broadcast what they're about to do, don't tend to stand in front of the person they're about to steal a child from and say, I'm going to call the police, I'm going to take the kids. You know, about that plan, what defense has termed as a secret plan to go along with the broken promises because Caitlyn wasn't following the defendant's plans. The word plan comes up a lot, and I apologize because it's hard to keep them all straight sometimes.
You don't have to mention
But
them.
Caitlyn
Just
never
don't.
called Brenda. She never texted her. She never asked for help. She never sent a code word, and Brenda never called 911. More important to your consideration, defense counsel advised you're not to Monday morning quarterback the defendant's choices, right? You're only to consider what he knew in that moment. And so if he didn't know that Brenda and Caitlyn had talked about this code word and 911 call plan, then he didn't consider it in the moments before he shot. What you do know is that the defendant didn't know about it and that it never actually happened. And because of those things, because he didn't know, you cannot use it to make the defendant's now stated belief that the defendant was going to kidnap the children become an actual belief or a reasonable belief. You know from his testimony that he only had suspicions. He didn't act on an actual belief, and his belief and his actions were not reasonable. On March the 1st of 2024, 16 hours after he had murdered Caitlyn, the defendant drove from Vermont into Keene. He told you that he was on his way to turn himself into police, to turn himself in for shooting and killing Caitlyn. He drove past multiple police stations in multiple states. He drove past the New Hampshire State Police Barracks at Troop C. He wanted to be arrested on his own terms. He knew that he would be taken into custody. He knew there would be an investigation, and he was ready for that. That's why he came back. He knew that speaking to the police was his opportunity to provide a statement about what had happened, his statement, and he wanted that opportunity. He wanted to speak with police and tell them why he shouldn't be in trouble for what he had done. But he didn't turn himself in. He got taken into custody at gunpoint in front of those two little girls whose mom he had killed. He had 16 hours to think about and prepare for this moment. He had 16 hours to determine what to say, what exactly to say and how to say it. He'd given himself the time and the space to put any spin that he wanted on the events that occurred in his living room. He'd had time to consider what it was he was going to tell police, how he would portray himself, how he would portray Caitlyn. Besides his 4-year-old daughter, there was no one to contradict him. And so he waived his Miranda rights. He spoke with investigators for over 2 hours. They let him talk about anything he wanted to address and just asked him questions to fill in the blanks. This was the defendant's opportunity to tell them why he had killed Caitlyn. He said she refused to leave. He said she was bear hugging their daughter, that she wouldn't let go, that he tried to pull the child away. If you listen in the tape, there's about 40 minutes where he talks about their background and his disputes with her and their custody issues. It's not until almost an hour in that he actually starts talking about the moment that Caitlyn was in his apartment and leading up to his killing of her. In those moments, at around, I believe it's 1 hour and 4 minutes, the defendant says he was trying to grab Elowen and be like, hey, let go of Elowen, and she just wouldn't do it. And that was kind of the tick. And then he says, I think the moment was definitely very deliberate and fast. It was like the line had been crossed. That her not letting go, her continuing to hold Elowen, was the only thing, the tick, the moment in his mind when he decided to kill, the moment when he decided to walk for his gun. And you know that he decided to kill in that moment because he did grab his gun. He racked the slide, he switched the safety off, and he walked over to shoot Caitlyn. And
We
know
lost
that
4-1.
Caitlyn saw him as he picked up that gun, because he told you in his testimony, she was closer to it than he was. And you know because you heard that gun as it racked when Jill Terrio was showing it to you. You know Caitlyn heard the racking of that slide. And for what the defendant would admit to in his testimony yesterday, she at least tried to ask him what he was going to do with it. But he didn't answer, because within seconds, he had shot her in the head, and Caitlyn was dead on the sofa. The defendant shot and killed her without a second thought, and he never, not one time, said anything about Caitlyn being a threat or a danger to anyone in that moment, not until he took the stand yesterday. Compare that to his actions as he described them in that story about the burglar in Nevada, a story that defense puts to you in their closing as explaining why he didn't call the police when Caitlyn was in his house. But it does so much more than that. It shows you the difference in behavior that the defendant has, the restraint that he can show, the fact that his muscle memory isn't all that's to him. A stranger trying to break into his home received more consideration than the mother of his children. That stranger was told to leave. He told them to go. He called the police. The defendant warned the stranger that he was armed with a gun. He went to the length to open the door and show the stranger the gun. He sat and waited with his loaded gun while the stranger tried the door, tried the windows, tried to break in. His muscle memory didn't take over. He didn't just shoot. The defendant never fired. He didn't shoot. The stranger walked away unharmed. But the mother of his children, she had to die. You listened to his statement during the presentation of the case. You have it in evidence, and you can listen to it again as many times as you want. You'll have a laptop back there that hopefully has a working CD player. You can listen to it, you can rewind it, you can jump to spots you want to hear. You should watch it. You should
Nick Recator actually talks a lot about that, used to do it a lot, where he said it should be a part of law school to learn how to do an oral presentation, that they actually should do some kind of acting class, because so many of them are really, really, really bad at presenting a case. This presentation has gone for 45 minutes so far. She she could have done this in 20 minutes, 30 at the absolute most, because this is an open and shut case. There's not that many witnesses. She'll have to recap. She just have to go in and say, what this lady before me said was bullshit, and this is why. Lawyers in America has one big mistake. They really like to hear themselves talk. They forget jury are people. No one, and this is scientifically proven, that's why lectures in school is 45 minutes long. No one can keep concentrating on your message after 45 minutes. Most people will have signed out before you get to the half hour mark. But that's why school is structured around a 45 minutes time span. And with the newer generation, you might even have to drop it because our focus can't be kept for that long. And the TikTok generation is even worse than we were. American lawyers need to shut the fuck up and get over with it. There's not enough evidence in this case that she needs to go for this long. Both closing arguments should have been maximum 45 minutes. This lady should have been done in half an hour. Out of there, tie a bow on it, go back to wait.
Compare it to the statements that the
Robinson.
defendant has now given to you from the witness stand. When you watch it, watch his demeanor, his body language, his facial expressions. Listen.
Yeah, but most of these prosecutors and defense attorneys are absolutely horrid at it. So you need some better coaches at law schools. Maybe get an acting coach. Something like posture and stuff like that. It's really, really bad. We got, as political candidates, we got called and had one big meeting every time we ran for election where we were told, remember to keep your back straight, try and keep your head up, don't slouch because you look like you don't believe what you're saying. All of these things. And I think you can tell why a person like Alan Jackson gets the big bucks, because he knows how to sell it. He's a really good communicator. If he's as good at facts like Alessi is, no. But Alessi also have a tendency to ramble a little bit. And that's why you pay the big bucks, because they know how to sell the product. And the product is your case to the jury. Most lawyers in America can't do that because they'll think, oh, I'll just say this, and I say this, and I say this, and that will convince them, and this will convince them. Brevity is way more important than all of these facts that she's trying to pinpoint, because they are not important. Go with the gun, must have been more than 3 feet away. She had all the rights to hold her own baby. He could have called the police. Bingo, bango. Why didn't he say anything about kidnapping till he learned the statute? You don't have to waste so much time.
Listen to the places where he hesitates or doesn't really answer the question that he's asked. Listen to the places where he scoffs, laughs, or smiles as he provides information to the police about where the bullet
They can't
struck
wrap
the
it up.
mother of his children. Listen to the information he gave the police and his reactions and behavior when this was still fresh in his mind, 16 hours
obviously
later,
did it to the right teacher.
when he hadn't reviewed any evidence against him, but instead was telling things as they had happened. Even then, much like the defendant spent 3 hours sitting on this witness stand talking about child custody and his life before children, as well as his love of his children, the defendant spent the first 40 minutes of that interview talking about those same things. Again, the defendant begins discussing the shooting about 40 minutes in and the reasoning for it about an hour in.
I probably have more time in court as a Danish layman than most of, maybe Larry DUI guy goes to court a lot because he has DUI cases. But I think I spend more time inside a courtroom than most lawyers do. I'm not practicing law, but I'm sitting in a courtroom listening as a juror. Most other law students don't go to court that often because MG does. MG is constantly in court. But Bricada wasn't a practicing lawyer. He hardly ever went there. Kurt, there's a lot. Branca, he's a consultant. He only gets expert testimony. So most lawyers don't go to courtrooms. Most lawyers will do plea deals and do like the kid work to try and keep Arabian oil sheik from paying taxes. I don't know why the kid does that, but she says it pays well.
He says that she was holding Elowen and refusing to leave. That's it, nothing else. Nowhere in the statement does he say that he acted because Caitlyn was using force to commit any crime, let alone a kidnapping or being about to commit a kidnapping. Nowhere in that statement does he say she was harming anyone or physically threatening anyone. Many of the statements that he made yesterday are not in the statement to police. He never told the police that night Caitlyn again demanded money from him or sell his car. He never told the police that he was concerned that Caitlyn could reach for a gun. He never told the police that Caitlyn put her foot on the table and tried to use that to push away from him. He never told the police that Elowen shrieked or yelled or cried out because she was being hurt. He never told the police that he taught Caitlyn to fire that gun. You know, the defendant told you that during his testimony that he wanted you to believe that he's adding this information because he was misunderstood. He wasn't misunderstood. His words weren't misinterpreted. He just never said these things, not for a year and a half. He is adding these things to change your opinion of him and of his actions, to try to get away with murder. The defendant spoke with detectives about every bad thing he believes that Caitlyn Naffziger had ever done to him or concerning their children. Is there any doubt in your minds that if she had said all these things he added from the witness stand, that he wouldn't have included them for the police? He'd had 16 hours to figure out to portray her as the villain and himself as the victim. The defendant has testified about being a Marine and being a father. Both of these things are true. But a third thing is true. He murdered Caitlyn Naffziger. He killed her out of anger, anger that she was questioning his plans, anger that she was remaining in his house and wasn't leaving like his plan said she would. You got to hear those 3 hours of testimony in which the defendant spoke about his history and his love of his children. You'll never hear Caitlyn Naffziger's history or about her love of being a mom, about her love for those same children, children she carried to term, her memories of their first years. You won't hear about Elowen's first Christmas when she was just 2 weeks old. All you got to hear was when Brenda Plamondon told you that Caitlyn was so loving and so happy to be a mom. You don't get to hear Caitlyn's story about those last moments of her life. She isn't here because the defendant killed her. The defendant killed her out of anger. He killed her because he wasn't going to lose power over her, he couldn't control her, and he wasn't going to swallow his pride again. The defendant is bigger and stronger and heavier than Caitlyn Naffziger. He talked with detectives about whether she'd ever been violent with him, and he told them he would never have registered it because she was so tiny. She couldn't hurt him if she tried. Not then, not ever. And one thing the defendant never said, not once, not during any statements with the police and not from the witness stand, is that Caitlyn never, ever hurt their children. There's no evidence.
End it there. End it there.
Now, the defendant wants
Brendan
you to
has the
believe that
same
he
problem.
shot this small, unarmed woman in defense of others, that this murder was justified, that he had no choice, that his use of force was somehow proportional, because the judge will explain to you that his use of force has to be proportionate to what he is responding to. The defendant wants you to believe that what he did was reasonable. He wants you to find that Caitlyn was committing or about to commit a kidnapping when he killed her, that she posed a danger when he killed her, and that this makes his killing valid, that he was right to shoot her in the head. All of this despite his clear testimony that he had shot and killed her just because she had hurt their child in the moments before the shot rang out. In order for you to find the defendant not guilty in this case, you would have to find that he acted in defense of others, that he both actually and reasonably believed that the mother of his children was committing a kidnapping or attempting to commit a kidnapping in that moment. Again, the defendant himself testified that he had suspicions, but you cannot kill someone over suspicions. It's not an actual belief, and it is not reasonable. The defendant testified that Caitlyn was threatening to call the police, that she threatened to take the children, but you cannot kill someone over a threat. That is not reasonable and is not an actual belief. There is nothing in the defendant's statements to police or even his testimony that demonstrates that deadly force was necessary or proportionate to the reason that he said he fired. He was a Marine. He was trained in martial arts. She was unarmed. The defendant didn't use deadly force because he had no other choice. He shot an unarmed woman in the head. He murdered Caitlyn. You have an evidence State's Exhibit 9A. So just blown up for the purpose of presentation. State's Exhibit 9A shows you Caitlyn as the defendant left her in that living room. This is a photograph of a mother sitting snuggled under blankets on a sofa, who has one foot kicked up on a coffee table, who has no shoes, no weapons, and poses no danger. This is a woman who moments earlier had a child on her lap. Their child. Their child. This is not a woman who was committing or about to commit a kidnapping when she was shot in the head. This is a woman with no friends in Berlin, New Hampshire. No friends in the area. Her family, a 2.5-hour drive away. She had never been there before. She had no car, no bus ticket, no means to leave. The defendant's reasons for shooting Caitlyn had nothing to do with the kidnapping.
Wrap it up.
He told you he shot and killed her because he believed that Elowen was being hurt. He described that Elowen was hurt during his efforts to take her from Caitlyn. He said Caitlyn hurt her by holding her too forcefully. A person cannot use deadly force to protect someone from being held too tightly by their mother. That's not reasonable. The defendant did not have an actual or a reasonable belief that Caitlyn was kidnapping or about to kidnap these children. There's no justification, no excuse. This is not a reasonable use of deadly force. The facts tell you that. The law tells you that. Your common sense tells you that. The defendant shot this unarmed woman in the head while she was sitting on a couch, wrapped in a pink unicorn blanket. He shot her because she refused to leave and was holding their daughter. This wasn't an accident. It wasn't self-defense. It wasn't to prevent a kidnapping. It was murder, and he knows it. And now, so do you. The
Wrap
time
it
for
up.
excuses is over. Please find him guilty of all of these charges.
Jeepers Christ, lady. That was horrible. It was 15 good minutes wrapped in an hour speech. If you get an hour, you don't have to use an hour. Like my love making, make it short, but make it count. At least make it short. Again, you go up there and say, remember when I told you at the beginning at the trial, we would prove to you. And then you get into the evidence showed that the gun must have been fired at a distance, no matter what she claimed about a hair. We don't dispute there's a hair there, but there's no explanation that it must have been a close contact wound. This was done at a distance while he was holding Eowyn. You cannot make any other inference from the evidence in the case. Second of all, he had no right. His whole story about kidnapping, you could hear he made it up after a year and a half. That story had no merit. She was sitting under a blanket with her kid, and all of a sudden he claims kidnapping. The easy solution would have been to call 911 and have her removed from the premises. There was no reason to escalate this to violence, no matter how much they were yelling at each other. This is not a kidnapping. It's not an attempted kidnapping. Even if the mom had a plan with her friend or aunt to remove the kids from the premises, he had no knowledge. He couldn't act on a kidnapping that he had no knowledge about. No matter how trained he is from the Marines, remember they are riflemen first, they don't read minds. That's over in the special section of the CIA, what's the men who stare at goats. So he had no knowledge about any attempted kidnappings. There was no one at the house who could help her with kidnapping the children. She wasn't wearing shoes. She didn't have a vehicle. He didn't even know that she had a plan to call the aunt. So how did he perceive the kidnapping? This is clearly constructed later to try and circumvent the clear murder he committed. Again, it's American lawyers, and their biggest problem is they like to listen to themselves speak. But they are done now, which means that we can jump over and do the Wisconsin trial. But let's just see, how long do you expect? 53% believes that in less than 2 hours, even though I said more than 2 hours. 37% believes 2 to 4 hours. 8% believes 4 to 6 hours, and 2% believes 6+ hours. Jamie and I have covered one New Hampshire self-defense case earlier. That was the guy who put 7-8 new holes in another guy, where 3 guys beat him up, where I clearly believe he had self-defense. New Hampshire doesn't believe in self-defense. So, and I don't believe that was the longest verdict watch we've been in either. They kind of did. But they didn't jump on it because, again, it's a self-defense case, so the reasonable doubt is kind of out the window. Yes, his convoluted story about how he is a rifleman and that's why he has to unalive people constantly, it just doesn't swim. He better hope that no one had any military training on the jury. It was a wild case, especially that's the last time I went in and saw witness impact statements, because I got so angry with the hypocrites of the victim's family, hypocrite, how bullshitting they were. But I'm going to redirect you over to the other stream. I'm going to set up stuff, and I'll be back in probably 5-10 minutes. Please follow me to Wisconsin, where we're going to see why did a body show up in the woods in a state that kind of looked like there might have been a sexual assault. We haven't heard anything about that other than she had her shirt pulled up, her bra pulled up, and her pants opened. She had been missing for 17 days. Her husband hadn't filed her missing. Doesn't look good for him. He claims he doesn't know anything about it. He had 2 girlfriends in the Philippines. Apparently, she talked to one of them. It seems like there's a lot of weird stuff going on in that case. Right close to where the body was found is a golf course. Brandon hasn't played it. He's going to go there next time him and Lefty's going out playing golf in Wisconsin. But there was also some kind of fire pit, burn pit, something, and some beer bottles. So was it a party area where people went and did the brown chicken, brown cow? Could there be an explanation other than, he got sick of the old ball and chain and he had to unalive her? Again, apparently so decomposed, it's hard to tell how she passed. So could be a better story over there. Hypocrisy. That's the word I was looking for. Baker sounds like every Chinese restaurant call in order. It'll be ready 5-10 minutes. It'll be ready. Maybe 10. Could be 15. But everyone, please join me over there and we'll go through this. We'll keep an eye on this. Hopefully one who is not streaming will keep an eye on it. If we have a verdict, we will cut back to it. And if you miss it because you don't want to watch the other case, I will try and clip that part out or just do a short of the verdict when it comes in, if it's a short one. I'm just going to end up renting out your local bar and not inviting you at this point. Why are you like that? I just invited you to join me on another stream. Brendan, I feel like Sue is getting to you. Not in a good way. I'm just going to take it over, set it up, make a new cup of coffee. It's not dinner time yet. So, come with us, Brandon. You are welcome, Brandon. And the next stream will also be sponsored by Brandon because he has been so generous today. So it's a full day sponsored. So I'm going to send you over, and then we're going to come back right snippy when I get everything set up. Non-sequitur. I don't know what that means. It's kumquat. The safe word is always kumquat. I bet you have been in his DMs on the Twits. Everyone, let's get to the other one, because this one is on the back burner now. On to the next one. See who killed who.